how does it strike you, this latest decision by her ladyship Justice Tokono to take her issues to the ECOWAS Court to seek justice for what she says is the violation of her human rights by this entire process to have her removed?
Oh, thank you. I think that the Chief Justice is now holding on to just anything, that will come their way. The ECOWAS Community Court indeed has jurisdiction to hear the cases bordering on violations of individual human rights. But the point is that the ECOWAS Community Court is a creature of the ECOWAS community, pursuant to their own protocols and treaties. And the first thing, presumptively, is that the ECOWAS Community Court will respect, the laws of member states. And one of the laws, the member states, is reserved for each other's, sovereignty. Indeed, the Lady Chief Justice, may take cases, to any court, even, go to the World Court, the Hague, anywhere. But the primary question is, has she exhausted, all the internal mechanisms here in Ghana? This is something that I find very difficult to understand. She's the Chief Justice. She has to respect the Article 146 CJ removal process. If she herself is disrespecting, the Article 146 CJ removal process, how does she expect the ECOWAS Community Court to intervene? Because first of all, they may, like to find out whether, there are any internal mechanisms in Ghana available. Are there remedies? Are there justiciable remedies? Now, this is a process that has been triggered under a constitution promulgated by the people, of Ghana for themselves, for the good governance of, the entire nation. She is the Chief Justice. And if she is not, prepared and willing to respect, own constitution, how does she expect ECOWAS, to intervene to protect her? I don't think that, the case is going to succeed. This is again one of the, cases with the dimmest prospect of success. It's doomed to failure, because the ECOWAS Court, indeed, it's a well-respected international adjudicatory body. But if you look at, what it has done in the past, it has, not simply interfered, with the internal processes. It only assumes jurisdiction in clear cases of violation of human rights. Here, I can't find any, human rights violation, perpetrated against Chief Justice Tokono. I think once again, it's a very bad approach.
If you say it's a very bad approach, and from you indicate that the ECOWAS Court would only pay attention to such matters if they, per their own consideration, the person who's brought the case to them has exhausted all internal avenues for redress or, as it were, remedy. But from where you sit, would you say that the suspended Chief Justice has not exhausted all the internal avenues for redress or the remedy to this situation of what she says the violation of her human rights, because she's taking the matter to the Supreme Court? It didn't go through. This injunction didn't succeed. She's at the High Court now seeking a judicial review as well. What else has not been done internally?
Again, you see, the office of Chief Justice is not, an individual's personal property. So this matter is not a personal matter. This is a constitutional process. Article 146 has been triggered by virtue of the submission of petitions to His Excellency, the President of the Republic. In every step taken, the president has respected the Constitution and actually acted in accordance with the provisions of the Constitution. There has been no clear case of violation of any human rights of a talk or no. The president has not breached any rule. If anything at all, the president has observed, the framework, that the framers of the Constitution put in place, that if you receive a petition, these are the constitutional steps you should take. And on each pathway, you have to respect, the will of the people as enshrined in the Constitution. The president has done that. It is the Chief Justice who has created a condition of, rendering the process, impracticable. Today, she does this. Tomorrow, she goes to Abidjan. Another time, she'll go to Togo and this thing. So, if you create conditions, that, render it impossible, to hear the case, the case or the petitions brought before the committee set up by the president in consultation with the Council of State, then it is she who is, rendering, the pathway intractable, not the president, not the people of Ghana. So she must allow, the constitutional process already triggered by the president, pursuant to the submission of the petitions, to, go to completion. Once the processes are determined judicially in accordance, with the framework spelled out clearly in Article 146, then and only then can one determine whether human rights have been violated or not. The ECOWAS Community Court has, on a number of occasions, dismissed suits, filed by aggrieved persons. On, certain occasions, it has, allowed, suits. But in all these things, the question is, have you exhausted the internal remedies provided by your own law?
Right. And I do appreciate your thoughts on this. And as I indicated, this new development is also attracting divergent views on whether or not this would go through or receive the attention of the ECOWAS Court. Kwaku Ansah Asare, I appreciate your time. Thank you, sir. Thank you so much for joining us.